Hi, welcome back to Akiona Law. I'm Lonnie Akiona, and on this podcast, we talk about everything related to family law and divorce. So we're picking back up again with our favorite triple T in family law and divorce paralegal, Jeanne Barrans. And we were talking about Jeannie's work as a triple T, which stands for a limited license legal technician. And in part one, we were discussing about what a triple LT can do in court, what family law and divorce cases it can help with, and what are the limitations. And we're talking about how the triple LT can assist the client at a temporary orders hearing, not make arguments in front of the court, but be up there to answer questions. And on today's podcast, we're going to focus on because the Triple T program was something that was new, that started in Washington. Jeannie, I believe you said in 2015 the program started, and you got licensed in 2016.
Well, the first licensed triple LTs were licensed in 2015. Sorry.
Oh, okay. No, I mean, and tell us about that. What is the Triple LT program?
Okay. Well, the Supreme Court for many years has been asking the Bar Association to look into where are the needs of the community. The civil legal needs study is what they were calling it, to find out where they're in what areas of law are they lacking in legal advice for folks who.
Yes.
And family law happens to be at the top of the list, and that's how they decided to license family law with this limited license initially. They've been looking into it for years before that, and I believe that they finally finalized the pathway, the classes that needed to be taken, and all of that to be able to, and the testing that needs to be done in 2012. But the first triple LT was licensed in 2015.
Okay. And what can you tell us about the program? Is it a 1-year program, a 2-year program? You're talking about classes?
Mm-hmm. Well, that depends. Everybody not everybody, but there are a few different paths. For me personally, I already had a certification as a paralegal. And so I didn't have to take what they called the core classes. That would have been a year through the University of Washington School of Law on core classes, which talk about the court system and explain how that process works and all of that sort of thing.
Oh, okay.
And then there's a year of practice area courses that follows that. So because I was already certified as a paralegal, I was able to take the practice area classes and then take the bar exam and then get my license. But for folks who aren't already certified, and there are only certain certifications that are allowed, that they would take a year of core classes and a year of the practice area classes. And I think that the core classes they are now being taught at the community college level, but that was not available initially. It was all through the University of Washington.
Okay, so it was a 2-year program.
Yes.
And you got to, because you're already certified as a paralegal, then you just took the specialty practice area so you could get that certification. And you said there were other certifications. There was family law, divorce, and is the other one bankruptcy?
No, there are no other certifications. Bankruptcy is actually a federal statute. So, and this is a state license. So I wouldn't be able to practice bankruptcy here with my limited license. But an attorney can practice bankruptcy law, of course.
Right.
Another difference between a triple LT and an attorney. But and we often do need attorneys as triple LTs. We often need attorneys for certain things, and like as we talked previously about drafting orders that divide pensions and that kind of thing. Right. So we do have to rely on attorneys as well for some things. But
so what was the other certifications that the triple LTs could get besides family law and divorce?
Unfortunately, they never approved another practice area. They had talked about landlord tenant.
Oh, yes.
And that did not go through. They talked about estate planning at one point, but that did not go through either. And then I don't recall that they talked about bankruptcy. I know they had talked about immigration, but again, that's federal, and so we wouldn't be able to help with that either.
I
But so
thought maybe,
that's the only approved
okay,
practice area is family law.
okay. And I thought I also heard some rumblings when they were talking about like possibly debtor creditor rights as
Yes,
well.
yes, they did talk about that. Creditor, I think it would be, on the creditor side, I suppose, although they never approved it, so I never really looked into it.
Right,
But I believe that would be, assisting folks and maybe communicating with creditors or something,
right.
try to maybe help mitigate some debt or something. I'm not quite sure what the intent was there, but that did not get approved either.
Which I thought would have been really helpful.
Yeah,
Um,
yeah, because
and
where are the people who need legal help and legal advice, and that they just can't always afford to pay an attorney rate, and my rates are less than half of what many attorneys charge. So
right. And in terms of, so congratulations on going beyond that paralegal certificate and getting that triple LT certificate. And you mentioned that you had to take a bar exam to get this
yes,
triple LT license.
yes, we call it the mini bar.
The mini bar. How many was it? Was it like a certain number of days?
Well, it was two, in my case, it was two sections. There's a ethics portion. It was all
Okay.
one day, but
Okay.
was it one day or was it 2 days? It was a few years ago now. I don't remember. No, I think it was just the one day, but you did the ethics portion in the morning, and then they had a multiple choice, and then they had um, uh, essay portion.
Oh gosh. So it is a very rigorous process.
It was, yes.
Yeah, that is a mini bar. Yeah,
Yeah.
congratulations again.
Thank
And you said, I'm sorry, you said that now, of course, the triple LT program, is no longer in existence.
Well, it's in existence in the sense that practicing triple LTs are going to be allowed to continue to practice, provided that they meet the
Right.
requirements to keep their license, in place. I know that there is at least one more group that's going to be testing coming up in January or
Okay.
February, and then I think there might be another one in July, but I'm not certain. I believe that July. My recollection is that July 2022 or summer of 2022 would be the last group that will be allowed to be licensed, because the Supreme Court decided to sunset the program, they call it.
Right. And how many triple LTs and sunset the program means there's, besides the current triple LTs are currently enrolled in the course, the program's not going to be moving forward where more people could get this license.
Well, not as it is now.
Yeah.
I mean, there may be another path. I hope there's another path, because
Okay.
I can tell you that every triple LT that I know is very, very busy. And so there is definitely a need for
Right.
triple LTs. And so I'm hoping that we can find another path to keep the license going, to be able to assist people.
And how many triple LTs do you know of that are licensed so far? Is it 20? Is it 30?
Oh gosh, no, I think it's in the 70s now. I would have
Oh,
to look it up
wow.
for sure.
Oh, gosh.
But yeah, I believe that there's 70 some, because we did just get several new licensed after the last testing. So I think that by the time all is said and done, when they come to July of next year, when the last group tests out, that we should be near 100, or give or take.
Oh, wow.
But
That's a
that's all
nice size.
across the state of Washington, so that's really not.
Oh, that's across the state of Washington, huh? Interesting. No, that's not a lot when you think about it that way.
No.
And what's the difference between, because again, you've been a family law paralegal for a very long time, and like you said, you got licensed as a triple LT in 2016. What's the difference between being a paralegal and a triple LT?
Well, as a paralegal, you can't give legal advice, and actually even telling people what forms to complete is considered giving legal advice according to
Oh,
yes, according to the court
No
rules.
kidding.
Yes. So, yes, and not the court rules, but this, yeah, it's a civil rule. I can't remember the number, but I'll look it up and tell you. But it says specifically, selection and completion of forms is a form of legal advice. So I can do that on my own as a triple LT. I can't do that as a paralegal. So sometimes when I have a case that I get to a point where I can no longer assist, such as a major modification of parenting plan that's not
Right.
agreed, and I turn it over to an attorney, if it gets turned over to an attorney in my office, then I can become the paralegal on that case, but I can no longer advise the client. I can't give legal advice to that client. I can pass on legal advice from the attorney, which I
Okay.
usually do by email, copying the attorney to make sure I get it right. But
Right.
so there's a big difference there in that respect.
So just to be clear, then the biggest difference between a triple LT and a paralegal is that the triple LT can actually give a legal advice to the client, but the paralegal cannot.
Correct.
Okay. And in terms of why would a person want to, like, I guess you can tell us, like, what are some instances or what are the situations or circumstances that people would want to come and use the services of a triple LT?
Well, for example, if they need help with their family law case and they can't find an attorney that they can, many attorneys will want an amount up front. Well, in fact, every attorney I know wants an amount up front, an advance fee, and typically those fees are not something that the folks that come to me can come up with. Most of them don't have those kinds of funds available, nor do they have family who can assist them with coming up with those funds. And so that's when they would come to me. But that's not always the case. There are sometimes people that come to a triple LT because they don't want to they don't feel that they need to spend as much as an attorney would cost. Maybe they've got an agreement and they just need help drafting the paperwork to put it together and get the divorce done with what they've agreed to. And then that's a perfect scenario for me, because then I don't really have to go to court for hearings and stuff, because I just put together agreed paperwork, they sign it, 90 days they get divorced, and that's it. So that's one instance. But child support modifications are expensive, or can be expensive. They are required to go to arbitration. I can assist the client with the arbitration, and I can assist with mediation and that kind of thing. So, and sometimes it's just a matter of mostly it's just a matter of just drafting the documents for the parties.
That brings me to a question. You talk about how just to touch about it, in our part 1 episode, you talked about how the triple LT can appear at court with your client, but you can't argue in front of the court. But if the court asks you questions, you can be there to answer a factual question. So I'm just trying to think. So you said you can help someone in mediation. So does that mean that you're going to appear in mediation with your client, and you'll be, talking to the mediator and engaging in that settlement and helping prepare the orders during mediation?
Yes, I can do that. I do have to have it specifically written what the parameters of my role are. So there's an agreement between me and my client that my client agrees that I can negotiate on his or her behalf regarding, maybe child support, spousal support, division of property, whatever it is that they want me to assist with. I have to have it in writing. But so and I can, then that also allows me to communicate with the opposing side. I need the client's consent to do that, and it has to be in writing for me to do that.
Okay. Yes. So if we were doing, because in Snohomish County, we do a lot of mediations via Zoom now, which I think is just wonderful and great.
Mm-hmm.
So you can be there on the Zoom with your client, and the mediator hops in, and you're there communicating with the mediator. Well, this is what my client is proposing, and this is why.
Mm-hmm.
Well, that would be so comforting.
Mm-hmm. Yeah, and it works pretty well. I mean, and my clients are there too, of course, on the Zoom meeting. So, so then they can chime in if they want, or sometimes they just maybe they just decide that they want, because the difference between mediation and arbitration is the mediator isn't a decision maker. That person's not going to make a decision for you.
Right.
So you don't necessarily have to present your case, as it were. You just, you kind of do, sort of, but not, it's not as intense. And so I think clients are a little more comfortable at mediation than they are in arbitration. But
do you remember, and I know you've been practicing it, you've been practicing it so much counter longer than I have, but remember way back when, back in the olden days before mediation was a requirement?
mm-hmm.
And I remember when they changed the rules to make mediation a requirement before trial, and there was a little bit of a pushback, but it turned out to be the greatest thing ever.
Mm-hmm. I think
So,
I do think it's a good thing, and
yeah.
we talked about in the first episode, where, and especially where there are parenting plans, because
Mhm.
judges and commissioners don't know your kids, and
Yeah.
they don't know you, and they don't know the other party. They just know, okay, well, we're going to make this decision for you because you guys can't seem to do it, and it's not always the best decision for the
No
kids.
one's happy.
And so I think mediation can really, with a good mediator, can really help with that.
Yes, a good mediator. In fact, when I talk to people, and even if they don't use my services for mediation, I tell people, make sure you use a family law and divorce attorney who's now doing mediation, because these issues are so complex. You need someone who specializes in family law and divorce.
Mm-hmm.
But I just loved it because I still remember that change. And I remember just thinking, wow, why didn't we do this mediation requirement earlier? Because so much cases were getting settled at mediation. And a mediation can be scary as well. So I love the fact that the LLLT, because you couldn't do that as a paralegal. You couldn't be there as part of mediation. But now as a LLLT, you can, and you can be participating and helping your client reach compromise and get orders that maybe, it's not 100% what they want, but a lot better than taking their chances in court and getting a big fat zero.
Yes. Yes.
So my next question would be, now this is really interesting, because knowing that you can't argue at a temporary orders hearing, can you present a case at arbitration for your client? Can you go argue?
No, I can be there with
Okay.
my client, and I
Okay.
can, so that my client can consult with me.
Okay.
But same at a trial. I wouldn't be able to present the case at trial either. I can assist them in preparing for trial. I can get trial notebooks together. I can be there with my client. I could sit at the table with my client, but my clients represent themselves.
Okay. And would it be kind of that same situation where if the court had any factual questions,
Mm-hmm.
would they ask you?
Mm-hmm.
Okay.
Regarding facts or procedures, yeah, they could ask me.
Okay. So that's interesting then. And that's because, as we all know, preparing for mediation, arbitration, or trial is very expensive. And so you'd be able to assist them with getting the arbitration brief, the binders, the proposed orders, the exhibit list, the witness list.
Mm-hmm.
You could do all of that. Well, let's not forget the evidence rule. What is it? The ER
904.
904. I always want to say 4 or something. The settlement rule, right?
Yeah.
Yes, the ER 904s together, which is basically that list of documents that you want to use at arbitration or trial, and they have to be submitted 30 days before the actual trial.
Mm-hmm.
So you can do all of that. So it's basically, you could do all of that preparation, appear with them at the arbitration or hearing, but not actually present the case.
Right.
Okay. And have you done any arbitrations or trial as in your LLLT role?
The only arbitration I've done is an arbitration on written submission, because it was a very narrow issue, and just that's where each party just sends information in writing and documentation to the arbitrator, and then the arbitrator reviews the information and makes a decision. So I have not had the opportunity to actually appear at arbitration. I have appeared at mediation a few times. I've not had the opportunity to appear at a trial yet, because most of my cases, they just don't go that far. They're done before that.
Well, I hear you too. And I think in terms of going to trial, again, just so many cases get resolved at that level of mediation right now. Mm-hmm. And what I particularly love about the Zoom mediation is that now we're not just limited to Snohomish County mediators. We can reach out to the King County mediators.
Right. Yeah.
So I think I love that part about the Zoom mediation, because then you don't have to worry about that travel distance
Yeah.
to King, because Seattle just seems so far away when you're practicing in Everett.
Oh, it does, or Bellevue or any of those. Yeah.
Yeah. Yeah. And so kind of switching gears in terms of, again, we're talking about how you assist in arbitration and trial preparation. So let's talk about final orders. So in terms of helping people to prepare final orders, you do that. I mean, and that's another thing too, right? And preparing final orders, and you've got kids, there's just, every time I do a divorce and there's no kids, I always feel like I'm missing paperwork, because I'm
Yeah.
always so surprised. Like, wait, there's just 2 documents. So as a triple LT, you'll help prepare the final parenting plan, right? There's a JIS form, there's a final child support order, the child support worksheet. And then I think what's really important is that you can, except for that pension division, you can prepare that division of assets and debts about who gets what.
Yeah.
Is that right?
Mm-hmm.
How do you like to do it within the divorce order itself about who gets what, or do you have your own, like I kind of have my exhibit A where I says who gets what, and I like to use that a lot.
Yeah, the law firm where I work, Brewery Lehman, they have an exhibit A and exhibit B.
Right.
For most of my clients, there's a lot in there that I don't use those. I just set it out in the orders. But it depends on how, what the assets and debts are. I mean, somebody comes in and they've been married for 6 months and they never commingled bank accounts or anything. It's pretty simple, and I don't use the exhibit A and exhibit B, but we do have those for the more complicated ones, and then I'll use those instead.
And I'm sure that must be, and again, there's just, in the life of a family law case, it's always, there's these stages where the petition and that motion for temporary orders is one big hill or hurdle, and then the next is mediation, and then the next is final orders. And I'm sure as clients, it must be so reassuring that they have you, a triple LT, or just you in general, to make sure that the T's are crossed and the I's are dotted.
Yes. And they do have to go to the pro se dissolution calendar on Wednesday afternoon to enter their final orders. Unless it's a parenting and support case, not a divorce or something. But they have to go in there, and the first one, this was back in 2016, where if my client was going to get final orders entered, but English was not her first language. So she wanted me to be there with her on that Wednesday. And I was glad I was there, because the commissioner said, they came in, they said, we don't want any child support order. This is what my client tells me. We've agreed we're not going to do any child support. So, well, you have to have a child support order, even if there's no transfer payment, because you have, there are other things that it addresses. And so I explained all that to her, and I prepared the support order, and I provided working copies to the commissioner, even though it's the pro se dissolution calendar. I always do that too. And then the commissioner said, what about child support? And my client said, no, we don't want child support. And the commissioner said, well, you have to have a child support order. And so she turned, and she had an interpreter there who was then telling her what the commissioner was saying. Okay. So I at that time, I was not allowed to stand up there with her. I was just sitting in the bench. And then I kind of got up and snuck up behind her, and I said, you have one, it's right here. So I was glad that I was there and able to do that, because otherwise she would have called after the hearing and said, that the commissioner wouldn't have entered the orders because there was no support order. Right. But in fact, it was there. And so.
Right. You can't just say, like how you were saying, you can't finalize a divorce and you don't have a final child support entered. The court is going to kick you out. Even if, like you said, the parties agreed on zero transfer payment, you still need to enter in that final child support order and worksheets.
Yeah, so, and the commissioner commented at that point. She said, well, I was a little surprised because everything else seemed to be very detailed and very, well organized. And so
thanks to you.
That was a compliment. Yeah.
Thanks to you.
Yeah.
That's really interesting, because that was one thing in terms, I was going to ask a question about, like, how do you go about, because as attorneys, we just, how you go about and finalize the case. Because as attorneys, we just walk into ex parte and say, Your Honor, I'm here with my client. We're here to finalize a divorce with kids. And I was going to, I really don't know, in Snohomish County, we have to do formal proof, which is, we ask the court has to take testimony in terms of the marriage is irretrievably broken, no one's pregnant, that list of a dozen questions to finalize a divorce, which the attorney has to put on the record with their client. Mm-hmm. So you said that, so you can appear in ex parte, you have to note it up on the pro se dissolution calendar to finalize the divorce?
To finalize a divorce, yes. Okay. But I can enter ex parte orders in other situations, like maybe a show cause order, or an immediate restraining order, or in a parenting and support case, as opposed to a divorce. I can enter those orders in ex parte. Typically, I send them over with a cover letter with a copy of the JIS cover sheet, and I say, here are orders that I've asked the JIS to be presented by such and such date, and they enter them that way. But there have been issues with that sometimes too, where sometimes the orders don't get entered for a long time. Then you have to wait. But so it's better if I have the time to walk over there and walk into ex parte and get those orders entered. But for a divorce, they do have to go to the pro se dissolution calendar.
Okay, so you said you can go into ex parte and get show cause orders. So you mean you could go in and get an order to show cause and contempt?
Yes.
Okay. So in terms of the pro se dissolution calendar, we were talking about how the attorney has to do formal proof with the client on the record. So are you just kind of doing that written formal proof then? Because you can't do it on the record? No, the court does it.
Yeah, the court does it. Yeah, okay. I don't do that. Yeah, the court does it. The court will swear the person in, and raise your right hand and swear to tell the truth or whatever, and then they ask them a few questions. That's a pretty simple process typically. But when you're as my client in the case I was just talking about, where English is not your first language, that's a little bit more complicated. And so it took me a while to explain to her that, about the child support order and what else was in the child support order, and that they had to have a support order. But, we got past it. But yeah, I was glad the interpreter was there too. So.
Well, again, there's just so many hurdles to jump through. Even with finalizing a pro se divorce, you've got to submit that, get your note up on the calendar, get your final order, submit that to the court, get that judicial information search background form, which a court needs before entering a final parenting plan. Then you got to check off, did my client complete the parenting seminar? Has that been submitted? There's so many steps. So it's nice that you're there to help guide them along the way. And then did you say you typically appear at that divorce finalization hearing with your clients?
I don't typically. I've only actually appeared one time. I only had one client, and that was that one that requested that I be there. And I'm happy to do it. I just, it is a simple process. And if your orders are agreed at that point, which they would be, or you wouldn't be entering them on that calendar, you would be going to trial or something. So, so they have agreed orders that and I just tell them, the few questions that the court's going to ask them, and they're welcome to pay me to be there if they want.
I see.
It's, I don't personally see the need unless they feel that they want me there for some reason, which she did, and that was fine.
Yeah, and it sounds like it was great that you were there, because otherwise she would have been kicked out. The court would have said, nope, I need that final child support order, and you had prepared it, and you were able to finalize your divorce. One thing I forgot to ask, and I can't believe I forgot to ask this, is do you help, and I'm sure the answer is yes, but do you help people prepare the petition for domestic violence, petition for anti-harassment?
I can, not anti-harassment. I can't assist in anti-harassment cases, but I can assist in domestic violence protection orders if the client chooses to have me do that. Typically, the domestic violence protection order office is pretty good about doing the initial step anyway. So that's usually where they go first, and then I can help them, when the other party responds, and then they have to reply and get the other order. So yeah, I can do those, but I can't do anti-harassment orders.
Why can't you do the anti-harassments?
Well, it's not family law necessarily.
Yeah,
It's not domestic,
right.
and often those are in district court, and I can't practice in district court. No, not
Oh, I
always,
see.
but
Okay, so oh, I get that. I get that. So I'm thinking about sometimes, like I've done this before in a case where but could you assist? Because I've had to do this before where maybe the level of facts for my client, and it was a marriage, it didn't rise to a petition for a domestic violence protection order, but he was like, you get, the husband sends like 50 texts to the wife.
hmm.
So we did a petition for anti-harassment instead between family members, husband and wife. Could you, and it was in Superior Court because it was family members. Could you help then?
No, I can't help in
Okay.
anti-harassment orders at all. It's
Okay.
specifically prohibited by APR 28.
Oh gosh. Okay. Well,
Mhm.
that's interesting. Well, at least you can help in those petition for domestic violence protection
Yes.
orders, because sometimes that can be overwhelming too.
Mhm.
Uh, so Jeannie, thank you so much for being on the show. And coming back again for the second half and continuing, just letting people know about triple LTs. I think it's a really great service, and I'm so happy that, because again, you're so smart and you've got so much knowledge and expertise in this area of family law and divorce to be able to help people. Is there anything? Is there anything in terms of like what would be the takeaway that you would want people to know about working with the triple LT?
Just to know that there is an option out there if you're not able to afford an attorney, or maybe you just don't feel like you need to have an attorney for whatever reason. You can contact any triple LT. They can tell you if there's something that's outside of the scope of their license, and they might have to engage the services of an attorney to assist with that. But there are options out there for you, and so you don't have to feel like you have to go it alone, because it can be daunting to try to
Yeah.
navigate the legal system.
Yes, very daunting. And how can people get a hold of you if they wanted to reach out to you for help,
Mhm.
have questions?
Well, they can call me at Brewery Lehman, which is the firm where I work, and the phone number is 425-252-5167. My email address is jeanneb@brewerylaw.com, and that's BREWELAW.
Thank you so much, Jeannie. And again, as Jeannie said, sometimes you don't always have to go to a family law and divorce attorney. There is an alternative. There's the triple LTs. They're a wonderful resource. They're able to give you legal advice. They're able to prepare your pleadings. They can go with you to court and just be there with you. They can't make arguments, but they will be there and able to ask any factual questions the court has for you. And just another great, wonderful resource to help people navigate the world of family law and divorce. Thank you so much, Jeannie, for being on the show. And I look forward to seeing you around town and seeing you in court, and hopefully not on the other side.
All right. Well, thank you for having me.
All right. Thank you. And thank you, everyone out there, for joining Akiona Law, where we talk about all things related to family law and divorce. I'm Lonnie Akiona. Until next time, thank you and stay safe.
The information in this podcast is general advice only and should not in any respect be relied on as specific legal advice.